client calls and they want everything. They want ultimate decision making authority or sole parental responsibility. They do not want to share time sharing. They do not believe in equal time sharing. And they believe that it is best that they make all major decisions on behalf of that minor child. Of course, as an attorney, you want to know why. You have to be curious about these situations and you have to be curious about these cases. You must elicit as much of your potential client's information and the facts of their case as possible to develop a sense for where the case might go, and if your potential client has a reasonable opportunity to make that actually happen. Perhaps one of the ugliest things that can occur in a family law case or any case is domestic violence. Domestic violence is, let's just say it, disgusting, disturbing, and unacceptable. And when it comes to parental responsibility with minor children, Florida Statute 6113 is real crystal clear, whether your client likes it or not, whether my client likes it or not. Now, the parties can agree to a contrary result. They can agree to one parent having ultimate decision-making authority, tie-breaking vote. They can agree to one parent making every single major decision on behalf of that minor child. A judge is certainly welcome to question that at final judgment or not sign off on the final judgment and ask the parties some questions and make a determination based on judicial discretion. Sure, of course. However, if one party asks for it and the other party rejects that claim to anything other than shared parental responsibility, well, we go ahead and look to the statute. The new statute as of 2023, which is always under legislation, as our friends let us know from the legislature and any sort of information system such as Westlaw or LexisNexis, or VLEX is one of the newer ones. It is the public policy of the state that each minor child has frequent and continuing contact with both parents, and there is a rebuttable presumption that equal time sharing of a minor child is in the child's best interest. One part, but the next part does not say rebuttable presumption. The next part states, and I quote, "The court shall." Shall means must, will, cannot deviate from. Order that the parental responsibility for a minor child under the age of 18 be shared by both parents. Here is the big part you need to be aware of. Unless the court finds that shared parental responsibility would be detrimental to the child. Now, of course, what is a detriment to the child? Could really be anything. Of course, case law separates what is and is not, but that is not an exhaustive list. In determining detriment to the child, the court shall, again, as in must, consider evidence of domestic violence, whether either parent has or has had reasonable cause to believe that he or she or his or her minor child or children are or have been in imminent danger of becoming victims of an act of domestic violence, sexual violence from the other parent against the other parent or against their shared children. And this is whether or not the cause of action is currently pending in the court. And why is that? Well, of course, any other relevant factors is the catch-all phrase. But why is it that the court shall consider that even if it is not pending? Because not everybody files for an injunction. Not every act of domestic violence, quite frankly, rises to the level of a guaranteed slam dunk injunction case. Also, if the danger is currently over and the two parties are separated, and the party that is the victimizer, the victim might know that the victimizer is a superior earner, might lose their job, putting their children in financial jeopardy or hardship. Or maybe the person that has been a victim feels that the danger is permanently over or fears any further reprisals. If the court knows about these things, they are beholden to consider the standard of what represents a danger or detriment to those children or to that child. I think that when people are always in a rush to say, well, I've made all the decisions for so long, It's not that the court doesn't care, it's that that is not statutorily the standard. And we now live under something of a one size fits all standard. It can be tested, it can be rebutted in some cases, but this is what the court must look to: a detriment to the child. Would it be a detriment to the child if both parents decide who their primary care pediatrician is going to be? Would it be a detriment to the minor children if both parents make a decision about whether or not your child needs a tutor? Think about it real carefully, ladies and gentlemen, before you invest in a lawsuit that tests this standard with or without proper foundation.